Hi, I'm Rebecca Goldfrank, Director of the Family Permanency Project at Children's Law Center, and I'm going to discuss today with you evidentiary issues that present while serving as a custody guardian ad litem. The first topic we'll discuss is how best to present issues to the court pretrial. There's a prohibition on ex parte contact between parties and chambers. And this prohibition arises both from judicial canons and the rules of professional conduct that govern attorneys' conduct. Children's Law Center is always available to answer any questions about what may be an appropriate topic to raise to chambers. Please feel free to contact us first before contacting chambers. Some issues that may be raised to the court on an ex parte basis are purely administrative matters. So if there are scheduling issues, you can first bring them to the court's attention, and they may direct you to file a motion, but it's not considered prohibited ex parte contact. Another important way that custody guardians ad litem and attorneys alike bring issues before the court is through the filing of motions. The guardian ad litem may choose to file a motion for a psychological evaluation, a motion for a home study, a motion for a court order to allow access to a child, or perhaps a motion to convert trial to a status hearing. There are many, many motions available for filing, and Children's Law Center has samples that we could provide you. We've found that it's more effective to have a motions-based practice rather than providing the court with hearsay statements or reports. A report is a term of art that refers to a document regarding the GAL's investigation. These reports frequently contain hearsay and make recommendations rather than have the attorney take a position on particular issues. We've found that motions are a much more effective way to get particular information before the court and to advocate for your client's interests. We think this is a better practice for attorneys because we are trained as attorneys and advocates, and also based on principles of fairness. There's no appropriate responsive pleading to a report. It's important that the guardian ad litem not become a witness because the guardian ad litem is not able to serve as both an advocate and a witness in the same proceeding. To that end, the guardian ad litem may want to bring a colleague or a paralegal with them when interviewing someone on a particularly controversial issue, and if necessary, that individual may serve as a witness at trial. It's also critical that the guardian ad litem be aware of the burden of proof at trial. Generally, the burden of proof is a preponderance of the evidence. When rebutting parental presumptions, however, the burden of proof is clear and convincing evidence. The movant in all of these circumstances has the burden, so that is typically the plaintiff or it is the party seeking to modify a final custody order. So what is the role of the guardian ad litem leading up to trial? The GAL must form a position consistent with the best interests of the child. At trial, the GAL must prepare to present and challenge evidence to advance that position. The GAL should anticipate calling witnesses or preparing examinations of witnesses and also introducing exhibits into evidence. A pretrial statement is an important tool in this process. Although the court may not always order a pretrial conference or that the parties submit a pretrial statement, it is good practice to initiate a pretrial statement. At a minimum, the pretrial statement should list out the witnesses the parties anticipate calling, provide a brief proffer as to what those witnesses will testify to, and list any exhibits that will be presented at court. The family court is fairly flexible regarding the evidence that will be admitted. Domestic Relations Rule 43 makes clear that the statute or rule which favors the reception of evidence governs. There's no comprehensive rules of evidence in the District of Columbia, and the law is primarily case law based. In terms of presenting evidence, we've listed here a few examples of witnesses that you might consider calling, and at a minimum, the GAL should interview in the course of trial preparation. So those include the parents and the caregivers, the teachers, therapists or social workers if they're involved, any of the evaluators who may have performed the psychiatric or psychological evaluations or the interactive assessments. You might also consider calling relatives to testify, although those relatives are typically less objective witnesses and so may provide less useful information to the court. It may be necessary that you call authenticating witnesses for records. And if you're contemplating calling the child to testify, this is very rare, and many judges on the Superior Court would prefer not to have the child come in and testify. If you're contemplating calling the child, please give us a call and we would be happy to talk that through with you. In terms of preparing examinations of the witnesses, for the guardian ad litem's own witnesses, the questions must be asked in open, non-leading form. For witnesses who are presented by other parties, typically the GAL will ask leading questions. So leading questions are short, pointed questions that don't have many subparts. There's no DC statute regarding child testimony or any special hearsay exceptions regarding children's statements. However, one of the factors that the court must consider in making a custody determination is the child's wishes. So frequently, the topic of child testimony does come up. We've listed here two very important cases that provide some guidance for custody guardian ad litems. We know that the custody guardian ad litem must take all steps to minimize any adverse consequences on the child of testifying. In re Jam J is a neglect case, and it discusses the neglect court's authority to set conditions on a child's testimony. The following case is in the custody context and is regarding in-camera interviews of children. In-camera interviews are permitted by the judge if harm to the child may result from testimony, but the interview must be recorded for purposes of due process and also for the appellate record. In terms of presenting evidence, you could consider presenting criminal records, drug testing results, those expert reports, home study reports, or letters. And now, we'll go back through. In terms of criminal records, in the District of Columbia, the only document that suffices as proof of a criminal conviction is a judgment and commitment order. And that's basically a document that lists out the crime that the person was convicted of and the sentence that the person received. You must get a certified copy of that document to be able to present it as evidence. It doesn't necessarily mean that the court will determine that that record is relevant to the instant proceeding, but for the court to consider it, the document, the judgment and commitment order must be obtained. Drug testing results. The GAL may subpoena the drug testing results from pretrial services, which is another office in the Superior Court. That is, of course, only if the parent or other party has been ordered to drug test by the court. Now, expert reports and home study reports are typically full of hearsay and may not be admissible. However, as we just learned, the domestic relations rule tend toward the admission of evidence. So it may be possible to admit those documents. Letters may also be admitted, possibly as admissions by party opponents. In terms of presenting your evidence, be sure to prepare your documents for trial and think through the basis by which you will get those documents into evidence. And you should also think about your objections to any other party's presentation of documents. The next 3 slides touch on basic principles for admission of documents into evidence. The first slide is regarding certified records. The second slide is a script for the business record exception to the hearsay rule. Keep in mind that when you're seeking to admit business records into evidence, there may be other layers of hearsay within those documents, and you will need to provide support for the admission of that information. The last slide is regarding judicial notice, which is frequently helpful in moving the case along and getting the court to notice certain important facts. I've just provided you some evidence tips in a nutshell. Please see the manual for any further information. And final words is to be bold about introducing evidence and always be prepared to respond to any evidentiary objections. Thank you for your interest in serving as a custody guardian ad litem and for providing such an important legal service to the children of DC.